My name is Lamont Flowers. I am the Executive Director of the Charles H. Houston Center for the Study of the Black Experience, and at Clemson University we emphasize the word study. Much of my work is focused on conducting research and trying to figure out better ways that we can frame what works in education for African Americans across the pipeline. I am very happy to have had the opportunity to co-develop this symposium with Professor Ogletree and Dr. Harris and the entire team at the Charles Hamilton Houston Institute for Race and Justice. I think I speak for all of us when I say what a marvelous opportunity this is to honor the enduring legacy of Charles Hamilton Houston, the winding road of the 2013 Supreme Court decisions. Given the title of this symposium, I think it's clear and that we have suggested, and in many ways I believe to some degree, that this past series of cases has been a winding road, but perhaps a winding road of rhetoric and maybe even some reality, and sort of that may in fact help us frame the very notion of democracy and opportunity and freedom in America. As I sort of dissect this winding road and humbly seek to repair parts of it, critical to my work really is the latest race-based affirmative action case, the Fisher case. And to me, this case particularly applies directly to the enduring legacy of Charles Hamilton Houston as it delves into questions of equal protection and equal opportunity. Thus, during my brief time, I will hopefully discuss what I believe are the critical issues and ideas and implications of this case, but from a researcher's perspective, from an educational researcher's perspective. My remarks, as I mentioned, are the result of a fairly extensive integrative review and educational research project in which I began by formulating a research problem in a scholarly context. So in preparation for this, I actually found it useful to sort of frame some guiding questions, some overarching questions, to sort of guide my thoughts as I thought about the complexities and layers of this case. Of course, the related issues and the practical considerations. I guess the first big question was, where do we go from here? In fact, this research and the way that I'm framing this for my center is attempting to predict how students and institutions are going to behave post-Fisher. Also attempting to frame this research around how high school students and families, schools and colleges and universities are going to function. For high school students, really the question is, how will this ruling and the related events sort of change their achievement behaviors? To what extent is it, or can it, or will it change students' achievement behaviors and their college admission strategies? For parents, how might this change the way that they prepare their children for college? For college students, of course, we're always interested in determining what are the effects of race and diversity experiences on student outcomes. For the high school students, I'm thinking that one excellent way to begin this research is perhaps to use Herbert Wahlberg's educational productivity model and attempt to control some very key variables as we look at the outcomes of achievement behaviors and college admissions outcomes for students, so that we could potentially control for those key variables that we know already impacts educational outcomes, while taking a look at the effects of the short-term and long-term effects of what it might mean in the future as students transition throughout the educational pipeline. For the college student research, I think it might be helpful for those of us who are doing this kind of work to employ the Pascarella and Terenzini methodological framework in that we could then control for pre-college variables and institutional characteristics and begin to learn a little bit about students' academic experiences and social experiences. The result of all this is to identify short-term and long-term outcomes for students and societies. So in other words, we know that colleges and universities will be changing. To what extent will this change the behavior of students, families, and schools? As I mentioned, I conducted an integrated review to sort of frame this, and the first phase of this project enabled me to sort of chart the path of the cases, and I thought that was very, very useful, again, from an educational research perspective. My attempt was to sort of glean some insight about the implications of these cases and, of course, the next steps. So I began in 1978 with the Bakke decision. As we know, that particular case, considered really in many ways, it's sort of the major mile marker on the winding road of the Supreme Court decisions involving, of course, race-based admissions. It, of course, stated that racial quotas and numerical set-asides could not be used in admissions. In that particular case, the medical school set aside 16 seats for minorities out of 100. The decision, of course, was that this practice was unconstitutional and therefore it was outlawed. And so, of course, colleges and universities now have to be very, very careful about assigning numbers to the number of students or even using any type of numerical information to sort of set limits on how many students by different races are entering the universities. What role does this play on universities in terms of admissions processes, and how are students and families thinking about this? These are some of the critical questions, sort of injecting the human element into some of this research and some of this work. So I guess, in a sense, from that particular case, 1978, the key ideas, in my opinion, was this notion that using race in admissions could perhaps be justified as a compelling state interest. And we're still really trying to figure out what the word compelling means. We're still trying to make sense of to what extent do race-based admission criteria, to what extent are they fair? To what extent do they violate or do not violate the Equal Protection Clause of the 14th Amendment? We're still struggling with these issues. And so I think from an educational research perspective, we need to truly, hopefully, try to define as best we can what it means to be a compelling interest. The way that we've done it so far is to cite educational research about the benefits of diversity. And again, we can debate some of those issues, but we're still working on that. The next stop on the winding road was the Grutter case in 2003. This case, as you know, was the University of Michigan's law school. Was sort of their policy was called into question. The good news is the Supreme Court decided that the law school's policies did not violate the students' equal protection rights, because while race was included in the admissions process, it was only one factor of many. So again, from my perspective here, the critical research issues, again, this issue of narrowly tailoring an admissions policy comes into play. And again, the research question is, what is that? How do we frame that for the future? How might we understand this better, not to simply defend it, but to understand its rationality for the future? Another mile marker on the winding road of race-based affirmative action was the Gratz case. Here, the University of Michigan's undergraduate admissions process was to actually assign points, 20 points, to students if, for example, if they were African American. And of course, going back to the 1978 Bakke decision, as we know, this practice was ruled unconstitutional because minority students were given points simply because of their race. And so we're still, sort of trying to figure out what should we do with these sort of issues? How might we frame admissions policies that are fair and just and do not violate students' rights, while at the same time increasing the diversity of our universities? This brings us to Abigail Fisher, who was denied admissions in 2008, who later sued the university, claiming that the university violated her equal protection rights. I find it interesting that the Brown decision was also argued primarily with the tool of the Equal Protection Clause, and we're sort of seeing these things come into play and still trying to make sense of what they mean. What does it mean to have equal protection for all students? And what is the impact of that on colleges and universities? In my opinion, really a key element of this current case, and we're finally in 2013, was that now colleges and universities must now show and demonstrate that it has considered and evaluated the use of race-neutral alternatives. It was also noted that strict scrutiny imposes now on the university the ultimate burden of demonstrating, before turning to racial classifications, that available race-neutral policies and alternatives did not suffice. So in terms of the implications of all of this, I think there's very little question, and of course the data studies support that race-based affirmative action has increased the number of minority students in colleges and universities, and other groups as well. On this point, really there is limited debate. But I think as an added dimension, we of course have to realize now that colleges and universities can of course still use race in admissions, but has to be narrowly tailored and only after the consideration of workable race-neutral alternatives. So from my review of all of these cases, from a research perspective, there are still some questions left unanswered. When might race-based affirmative action no longer be needed? Can universities still justify this compelling interest of student body diversity? And what are some useful race-neutral alternatives for creating a diverse campus? In regards to the first question, I think we need to keep in mind that at some point, maybe in the near future, it is possible that race-based affirmative action may end. In 2003, in fact, Justice O'Connor noted, and I quote, "It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. Since that time," she noted, "the number of minority applicants with high grades and test scores has indeed increased." This is the key point. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. So regarding the question of compelling interest, I think it's also important to look at the census latest population projections. As we know, minorities now constitute about 37% of the population. In 2060 or so, it's estimated that we will compromise 57%, comprise 57% of the United States population. From another standpoint, in regards to the Fisher case, I think we have to also consider that now colleges and universities are held to a higher standard, a stricter scrutiny, if you will, in that they will now have to show that they've explored race-neutral alternatives. I think most importantly, and sort of a under-noticed idea, is that this ruling has also empowered colleges and universities to construct the student bodies that they want to construct, that they deem appropriate to promote educational outcomes. We have a host of studies and series of studies and research, Dr. Gurin's work, Dr. Emily Shaw's work at the College Board, which ultimately suggests that racial diversity and interactions with students of other races does increase student outcomes, things like interracial interactions with students during and after college. And of course, these findings are consistent really with Gordon Allport's intergroup contact theory, which suggests that the more time you spend with people of other races, the more likely you are to sort of reduce prejudice, he noted, and lead to more positive cross-cultural interactions. I hope to take up some of these issues during the question and answer period. And of course, I've sort of set up a series of research questions I hope for you. These are things that I have to take back to Clemson University as I work with researchers and others as we think about the next steps. While I think, of course, we have a lot of work to do, I do think we can get there in terms of making sense of all these complex issues: equal protection versus fairness, diversity experiences versus compelling interest, race-neutral alternative versus race-based alternatives. I think we can get there. I think we do have the capacity really as a nation to sort of make the right decisions over time. And I do think this is a worthwhile goal. And we have to continue to work in this regard as we attempt to make this nation even better. Thank you.